Hi, I'm Amy Varel. I am a partner in the law firm of Boylan Code located in Rochester, New York. Today I'm going to talk about some employment laws that were passed this year affecting New York State-based employers. First, I'm going to talk about the pay transparency law that was passed this year and became effective on September 17th. That law requires New York State employers to disclose in job advertisements the compensation or range of compensation for the job and also a job description if it exists. If the employer gives a range, it must have a minimum and a maximum. For example, it cannot say $20 an hour and up. It also cannot say a maximum of $50,000 per year. The compensation should be the amount that the employer believes in good faith to be accurate when it's posted. Good faith means the employer is including the amount or range of compensation the employer legitimately believes they're willing to pay the successful applicant or employee at the time they post the advertisement. If the range posted is more than the employer plans to or can afford to pay, then it's not in good faith. And the amount can change after it's posted. Of course, it can always go up. And if the employer can also adjust it in good faith after collecting additional information in the hiring process. The amount posted should not include benefits, and it should, such as insurance or overtime pay. And the job advertisement also has to include a job description if it exists. It may not exist if the position or title clearly conveys the job. For example, a dishwasher wouldn't require a separate description. If the job is based on commissions, the job posting can't say that. So who is required to comply with this new law? All jobs that will be physically performed in New York, or at least in part New York, are required to comply. Infrequent or single instances of being physically present in New York would not make the employer comply with this law. For example, if the employee is required to attend an occasional meeting or conference in New York State, or if the employee is working with employees that are based in New York, the employer would not be required to comply with this law. However, remote positions can fall into this new law if the job is physically performed outside of New York but reports to a supervisor, office, or other work site in New York. Those job positions would apply. All job advertisements are covered regardless of the medium. A job ad is defined as a written description of an employment opportunity that is made available to a pool of potential applicants for internal or public viewing, including electronically. The law applies to both internal and external postings in any type of medium, including newspaper ads, printed flyers, social media posts, even an email that's sent to a pool of more than one applicant, or an email through an electronic mailing list. The law applies if the job ad is posted by a third party on behalf of the employer. However, it does not apply in cases where a third party, without the employer's permission, takes the ad and posts it elsewhere. The law also does not require that the employer use any specific type of medium. The penalty for failure to comply are up to $1,000 for the first violation, up to $2,000 for the second violation, and up to $3,000 for the third violation.